Many Canadians already have an idea of how trials work from various sources, media, and of course popular crime shows. We all know about the judge, the defendant, the jury, the pleas, and of course the all important verdict to be innocent or guilty. And while all the action packed, high intense drama that we often see in televisions give us our representation and view of trials is certainly entertaining to watch, but not entirely reflective of reality and how our trial system actually works here in Canada. For example, you may be familiar with the roles of judges and lawyers, but puzzled as to what exactly a crown attorney even does. It is important to note that unlike in the American legal system, where every state might have their own different systems, in Canada, all the provinces would follow the federal law. Likewise, in the United States, there are some judges which are elected into office, while in Canada, all the judges are appointed by either the provincial or federal governments. And of course, Canada's identity as a bilingual country means that trials in Canada can proceed in either English or French. And of course, everyone has the right to be understood in a trial, and for cases where English or French may not be spoken, an interpreter would be present. As different states have different systems, some still have the death penalty, while in Canada, action had been abolished in 1972. Of course, you may have heard about the fifth plea, which allows witnesses to decline in testifying if questions asked would work against the accused and possibly lead to incriminating themselves. This is similar, of course, to the Section 13 in the Charter of Rights and Freedoms, in which Canadians do have a similar right, however, witnesses won't be able to outright excuse themselves from testifying. So, you may be wondering, what is fact or fiction? How did we even get here? Is any of it even real? And the answer is yes, just kinda different. So let's get back to before the trial and discuss the processes involved and how Canadian trials actually work. To begin with, here in Canada, we have what is called an adversarial system, in which every individual is perceived innocent until proven guilty without a doubt under the law, and can't be arrested until proven so. In this system, both the defendant and the Crown will have a chance to present their case in front of a judge or jury. Unlike in America, where the arrest is the first step in the process, the Canadian legal system begins with investigation. So the Crown Attorney, who's a lawyer representing the government and authorities, would be working and finding evidence against the accused in order to make a case. Now, in order for the Crown Attorney to proceed with the case needs to be strong enough for conviction. Keep in mind, when the Crown is presented with a case, he or she would then decide to either proceed or not to proceed. If the Crown decides not to proceed due to different factors, such as there not even being a prospect of conviction, or if it's not in the public's interest, then the person would not have a criminal record and may be referred to counseling instead. If the Crown decides to proceed, then the accused would have two choices, either to plead guilty or not guilty. If the accused pleads guilty, then no trial is needed, and the accused would then be sentenced by a judge who will determine the sentencing based on precedent and the law. Depending on the crime and the case, the judge may choose conviction, probation, fines, and other punishments. Now, if the accused pleads not guilty, then a trial would need to take place. The accused would have the choice of having the case heard with or without a jury. The Crown Attorney would then work finding evidence against the accused and would be the first to present their case in a criminal trial, while the defense lawyer would be representing the accused and attempt to sway the judge or jury by providing counter evidence in order to show that the accused is in fact innocent. This would proceed as a back and forth between the Crown and the defendants. After the trial, the judge or jury will deliberate based on the law and the evidence presented and decide if the accused is in fact guilty or innocent. If the accused is found guilty, then they will need to be sentenced by the judge at a later date, and if found not guilty, then all charges would be dropped and the person would not have a criminal record. Canadians, it's important to realize the significance of knowing how your own trial system works, because in Canada, the rule of law applies to everyone equally. And this means that this is a topic that would affect us all, regardless of gender, race, or class.